If the tribunal please, when the tribunal adjourned, I had just dealt with the last of the two Norway documents, which I now put in as exhibits GB 140 and GB 141. Their numbers were 004 PS and D629. My Lord, for convenience, the first document to which I shall refer in a few minutes will be document number 871 PS. 1871 PS. Lord,
I've got that here.
You have, if your Lordship pleases. My Lord, before I come to that, I just want to say one word about the aggression against the Low Countries, Belgium, the Netherlands, and Luxembourg. The facts as to the aggression against these countries during the period when this defendant was foreign minister were stated in full by my friend Mr. Roberts. I think if I give the tribunal the reference to the transcript at pages 1100 to 1125, I don't need to detain the tribunal on that part of the case. I only remind the tribunal that the action of this defendant as foreign minister, to which attention may be called, is the making of a statement on the 10th of May 1940 to representatives of the foreign press with regard to the reasons for the German invasion of the Low Country, and these reasons were, in my respectful submission, demonstrated to be false by the evidence called by Mr. Roberts, which appears in that part of the transcript. My Lord, I then proceed to the aggression in Southeastern Europe against Greece and Yugoslavia. And the first moment of time in that regard is the meeting at Salzburg in August 1939, at which the defendant von Ribbentrop participated, when Hitler announced that the Axis had decided to liquidate certain neutrals. That is document 1871 PS, which I now put in as exhibit GB 142, and the passage which I should like to refer the tribunal is on page 2 of the English version, 2/3 down the page, in the middle of the 5th paragraph, 6 lines from the top. The Lordship will find the words, generally speaking.
Yes, thank you very much.
I desire to quote from there. Generally speaking, it would be best to liquidate the pseudo-neutrals one after the other. This is fairly easily done if one Axis partner protects the rear of the other, who is just finishing off one of the uncertain neutrals, and vice versa. Italy may consider Yugoslavia as such an uncertain neutral. At the visit of Prince Regent Paul, he, the Führer, suggested, particularly in consideration of Italy, that Prince Paul clarify his political attitude towards the Axis by a gesture. He had thought of a closer connection with the Axis and Yugoslavia's leaving the League of Nations. Prince Paul agreed to the latter. Recently, the Prince Regent was in London and sought reassurance from the Western powers. The same thing was repeated that happened in the case of Gafencu, who was also very reasonable during his visit to Germany and who denied any interest in the aims of the Western democracies. Afterwards it was learned that he had later assumed a contrary standpoint in England. Among the Balkan countries, the Axis can completely rely only on Bulgaria, which is, in a sense, a natural ally of Italy and Germany. Then, missing a sentence, at the moment when there would be a turn to the worse for Germany and Italy, however, Yugoslavia would join the other side openly, hoping thereby to give matters a final turn to the disadvantage of the Axis. That demonstrates the policy with regard to uncertain neutrals. Then, as early as September 1940, this defendant reviewed the war situation with Mussolini. This defendant emphasized the heavy revenge bombing raids in England and the fact that London would soon be in ruins. It was agreed between the parties that only Italian interests were involved in Greece and Yugoslavia, and that Italy could count on German support. Then von Ribbentrop went on to further to explain to Mussolini the Spanish plan for the attack on Gibraltar and Germany's participation therein, and that he was expecting to sign the protocol with Spain, bringing the latter country into the war on his return to Berlin. That is document 1842 PS, which is the next document in the book to the one which the tribunal has just been looking. And the passage with regard to Greece and Yugoslavia occurs in the middle of the first page. If I might just read a very short extract. I quote, "With regard to Greece and Yugoslavia, the foreign minister stressed that it was exclusively a question of Italian interests, the settling of which was a matter for Italy alone, and in which Italy would be certain of Germany's sympathetic assistance." Don't think I need trouble the tribunal with that.
You better need read the next sentence.
Oh, but it seemed to us to be better not to touch on these problems for the time being, but to concentrate on the destruction of England with all our forces instead. Where Germany was concerned, she was interested in the northern German districts, in Norway, etc., and this was acknowledged by the Duce. Very grateful, Your Honor. Okay. Whereas that I put in as Exhibit 143. A month or two later, in January 1941, at the meeting between Hitler and Mussolini, in which this defendant participated, the Greek operation was discussed. Hitler had stated that the German troops in Romania were for use in the planned campaign against Greece. That document is C-134, which was put in as Exhibit GB 119, and therefore I don't propose to read it again. I just give the tribunal the reference to the point which I mentioned is at the foot of page 3 of the English text. With regard to that meeting, there is a cross-reference in Count Ciano's diary, Count Ciano having attended as Italian foreign minister, and he records his impression of that meeting in the diary for the 20th, 21st of January by saying, "The Duce was pleased with the conversation on the whole. I am less pleased, above all because Ribbentrop, who had always been so boastful in the past, told me when I asked him outright how long the war would last, but he saw no possibility of its ending before 1942. Despite that somewhat pessimistic statement to Count Ciano, a short time later, 3 weeks later, when it was a question of encouraging the Japanese, this defendant took a more optimistic line. On the 13th of February 1941, he saw Ambassador Oshima, the Japanese ambassador, and that is the conversation appears in the document 1834 PS, which is United States Exhibit 129. That was read previously, and again I simply give the reference on page 3 of the English version, the second last paragraph, where there is dealt with the optimistic account of the military position and the position of Bulgaria and Turkey. I don't think I need to read it further, but I give the tribunal the reference.
Which page was it on?
On page 3 of the document. Oh, I'm sorry, my lord, that's my fault. It's marked page 3 at the top. It's actually page 3 if you count the distribution page. It's marked page 3 at the top, and it's a paragraph that begins militarily. Militarily, the Reich Foreign Minister continued, the Führer had created a number of new formations. Then, after that, in March, this defendant put forth his efforts to get Yugoslavia to join the Axis, and on the 25th of March, the defendant, in a note to the Prime Minister, Svetkovic, said, then this is document 2450 PS, which is Exhibit GB 123. He gave the assurance the Axis power governments during this war will not direct a demand to Yugoslavia to permit the march or transportation of troops through the Yugoslav state or territory. After that, it's only fair to point out that there was the coup d'etat in Yugoslavia. General Simovic took over the government, and 2 days after the assurance which I've just read, at the meeting of the 27th of March 1941, which this defendant was present, Hitler outlined the military campaign against Yugoslavia and promised the destruction of Yugoslavia and the demolition of Belgrade by the German Air Force. That is contained in document 1746 PS, which is Exhibit GB 120, and that was read by my friend Colonel Phillimore at an earlier stage, so I don't read it again. The final action of this defendant with regard to Yugoslavia was that after the invasion of Yugoslavia, von Ribbentrop was one of the persons directed by Hitler with the drawing of the boundaries for the partition and division of Yugoslavia. Preliminary directive for that is document 1195 PS, which I now put in as Exhibit GB 144. now come to the aggression against the Soviet Union, and the first...
Has that been read, 1195?
That was the last one.
Has it been read?
Yes, I put in 1195. That's the directive for the partition of Yugoslavia.
Yes, but you aren't reading it. Has it already been read or not?
No, it hasn't. May I read, I'm much obliged, Your Lordship. May I read the relevant sentence with regard to this defendant?
Yes.
On page 2, section 2, Your Lordship will see the words, the drawing up of boundaries.
Yes.
And paragraph 1 says, if the drawing up of boundaries has not been laid down in the above part, it will be carried out by, above part 1, it will be carried out by the Supreme Command of the Armed Forces in agreement with the Foreign Office, that's this defendant, the plenipotentiary of the 4-year plan, the defendant Goering, and the Reich Minister of the Interior.
Frick, is it? Who's the Reich Minister of the Interior?
I think the defendant Frick.
Yes, I think it was.
Lord, I'm grateful to Your Lordship. I forgot that hadn't been read before. Now, then, as I say, we come to the aggression against the Soviet Union, and the first document which hasn't been put in so far, which I now put in as Exhibit GB 145, is TC 25, the German-Soviet Non-Aggression Pact. On the 23rd of August 1939, this defendant had signed the German-Soviet Non-Aggression Pact. Now, the first point at which this defendant seems to have considered special problems of aggression against the Soviet Union was just after the 20th of April 1941, when Rosenberg, the defendant Rosenberg and this defendant met or communicated to consider the problems which were expected to arise in Eastern occupied territory. And this defendant appointed his counselor Grosskopf to be his liaison with Rosenberg, and also assigned a consul general called Grautigam, who had many years' experience in the USSR as collaborator with Rosenberg. That is shown in document 1039 PS, which is already United States Exhibit 146. I didn't propose to read it again as it had been read, but the passage which I've referred is at the first paragraph on the top of page 2, beginning after notification to the Reich Foreign Minister. It's that paragraph which I've just mentioned. That was in April 1941. The following month, on the 18th of May 1941, the German Foreign Office prepared a declaration setting forth operational zones in the Arctic Ocean, the Baltic and the Black Seas to be used by the German Navy and Air Force in the coming invasion of the Soviet Union. And that is the next document, C-77, which I now put in as Exhibit GB 146. And it's very short, therefore I think I should quote it. It hasn't been read before. the Foreign Office has prepared for the use in Barbarossa the attached draft of a declaration of operational zones. The Foreign Office, however, reserves its decision as to the date when the declaration will be issued, as well as discussion of particulars. Therefore, these last two documents show quite clearly that this defendant was again well in the preparation for this act of aggression. Then, on the 22nd of June 1941, this defendant announced to the world that the German armies were invading the USSR, as was seen by the tribunal in the film shown on the 11th of December. And how untrue were the reasons given is shown by the report of his own ambassador in Moscow, who said that everything was being done to avoid a conflict. The tribunal will find the reference to that in my learned friend, the Attorney General's speech, the transcript at page 888. We now come to the aggression which involved Japan and was directed against the United States of America. And there, the initial document is the 2508 PS, which I now put in as Exhibit GB 147. That shows that on the 25th of November 1936, as a result of negotiations of this defendant as ambassador at large, Germany and Japan had signed the Anti-Comintern Pact. I don't think that has been read, but if I might just read the introduction, the recital, that gives the purpose of the agreement. The government of the German Reich and the Imperial Japanese government, recognizing that the aim of the Communist International, known as the Comintern, is to disintegrate and subdue existing states by all the means at its command, convinced that the toleration of interference by the Communist Internationale in the internal affairs of the nations not only endangers their internal peace and social well-being, but is also a menace to the peace of the world, desirous of cooperating in the defense against communist subversive activities, have agreed as follows. And then there is follows the effective terms of the agreement with which they will act together for 5 years. It's signed by this defendant. On the 27th of September 1940, this defendant, as foreign minister, signed the Trapata Pact with Japan and Italy, thereby bringing about a full-scale military and economic alliance for the creation of a new order in Europe and East Asia. That is 2643 PS, United States Exhibit 149, and has been read. Then, on the 13th of February of 1941, it is a month or two later, this defendant was urging the Japanese to attack British possessions in the Far East. And that is shown in document 1834 PS, which is U.S. Exhibit 129, and which has already been read by my friend Mr. Alderman. Then, that was February. In April 1941, at a meeting between Hitler and Matsuoka representing Japan, at which this defendant was present, Hitler promised that Germany would declare war on the United States in the event of war occurring between Japan and the United States as a result of Japanese aggression in the Pacific. And that is shown in document 1881 PS, United States Exhibit 33, which has already been read, which I didn't intend to read again. And then the next document which reinforces that point is 1882 PS, which is United States Exhibit 153. If I might trouble the tribunal with just 2 short paragraphs of that, it's interesting as showing the psychological development of this defendant and his views at that time. So the first 2 paragraphs that are quoted, there's a bracket heading, pages 2 and 3, then it begins, Matsuoka, it's on the first page of the document. Matsuoka then spoke of the general high morale in Germany, referring to the happy faces he had seen everywhere among the workers during his recent visit to the Borzig works. He expressed his regret that developments in Japan had not as yet advanced as far as in Germany, and that in his country the intellectuals still exercise considerable influence. The Reich Foreign Minister replied that at best a nation which had realized its every ambition could afford the luxury of intellectuals, some of whom are parasites anyway.
Most, according to my document.
Oh, most, I beg your lordship's pardon. It's completely my fault. It should be most. Most of whom are parasites anyway. A nation, however, which has to fight for a place in the sun must give them up. The intellectuals ruined France. In Germany, they had already started their pernicious activities when National Socialism put a stop to these things. They will surely be the cause of the downfall of Britain, which is to be expected with certainty. Then it continues on the usual lines. That last document was on the 5th of April. Then, with the next stage, within a month after the German armies had invaded the Soviet Union, the 22nd of June 1941, Ribbentrop was urging his ambassador in Tokyo to do his utmost to cause the Japanese government to attack the Soviet in Siberia. And that is proved by 2 documents which have already been put in. 2896 PS, which is United States Exhibit 155, a telegram to the German ambassador in Tokyo, 1 Ott, and 2897 PS 156, which is the reply from Ambassador Ott. Both of these were read by my friend Mr. Alderman. I don't trouble the tribunal again. But the next document, which is D656, is a new document which I put in as GB 148. That was captured from the Japanese, and it's a message intercepted which was sent by the Japanese ambassador in Berlin just before the attack on the United States. And if I might just read one short extract from this defendant's speech. On the 29th of November 1941, that is roughly a week before Pearl Harbor, this defendant was saying, I think I better, it's in paragraph 1. I'll read it all because it is new. Ribbentrop opened our meeting by again inquiring whether I had received any reports regarding the Japanese-United States negotiations. I replied that I had received no official word. Ribbentrop: it is essential that Japan effect the new order in East Asia without losing this opportunity. There never has been and probably never will be a time when closer cooperation under the Tripartite Pact is so important. If Japan hesitates at this time and Germany goes ahead and establishes her European new order, all the military might of Britain and the United States will be concentrated against Japan. As Führer Hitler said today, there are fundamental differences in the very right to exist between Germany and Japan and the United States. We have received advice to the effect that there is practically no hope of the Japanese-United States negotiations being concluded successfully because of the fact that the United States is putting up a stiff front. If this is indeed the fact of the case, and if Japan reaches a decision to fight Britain and the United States, I'm confident that that will not only be to the interest of Germany and Japan jointly, but would bring about favorable results for Japan and herself. Then the ambassador replied, I can make no definite statement as I am not aware of any concrete intentions of Japan. Is Your Excellency indicating that a state of actual war is to be established between Germany and the United States? Defendant Ribbentrop: Roosevelt's a fanatic, so it is impossible to tell what he would do. Concerning this point, in view of the fact that Ribbentrop has said in the past that the United States would undoubtedly try to avoid meeting German troops, and from the tone of Hitler's recent speech, as well as that of Ribbentrop's, I feel that the German attitude towards the United States is being considerably stiffened. There are indications at present that Germany would not refuse to fight the United States if necessary. And then the next part, section 2, is an extremely optimistic prognosis of the war against the Soviet Union. I don't think, in view of the date in which we're reading it, that I need trouble the tribunal with that. There are then a few remarks about the intended landing operations against England, which is also vieux jeu at this time. But if the tribunal would go to part 3, there again we get the international attitude of mind of this defendant. That's the foot of page 2, part 3. In any event, Germany, I'm quoting, in any event, Germany has absolutely no intention of entering into any peace with England. We are determined to remove all British influence from Europe. Therefore, at the end of this war, England will have no influence whatsoever in international affairs. The island empire of Britain may remain, but all of her other possessions throughout the world will probably be divided 3 ways by Germany, the United States, and Japan. In Africa, Germany will be satisfied with, roughly, those parts which were formerly German colonies. Italy will be given the greater share of the African colonies. Germany desires above all else to control European Russia. And after hearing this defendant, the ambassador said, I quote, "I am fully aware of the fact that Germany's war campaign is progressing according to schedule smoothly. However, suppose that Germany is faced with the situation of having not only Great Britain as an actual enemy, but also have all of these areas in which Britain has influence, and those countries which have been aiding Britain as actual enemies as well. Under such circumstances, the war area will undergo considerable expansion, of course. What is your opinion of the outcome of the war under such an eventuality?" Defendant Ribbentrop, "We would like to end this war during next year," that's 1942. "However, under certain circumstances, it is possible that it will have to be continued on to the following year. Should Japan become engaged in a war against the United States..."
You're going a little bit too
Germ-
fast.
Oh, too fast?
Well, apparently.
If you want to, please. Sorry. I'll go back to the paragraph I've just finished. Defendant Ribbentrop, I'm still quoting, "We would like to end this war during next year. However, under certain circumstances, it is possible that it will have to be continued on into the following year. Should Japan become engaged in a war against the United States, Germany, of course, would join the war immediately. There is absolutely no possibility of Germany's entering into a separate peace with the United States under such circumstances. The Führer is determined on that point." That document associates this defendant with the aggression by Japan against the United States in the closest possible way. The other new document, which is also intercepted Japanese diplomatic message, is the next one, D657, which I put in as Exhibit GB 149, and if I might read the first two sentences, that shows what it is. I quote, the Japanese ambassador says, "At 1 p.m. today, the 8th of December, I called on Foreign Minister Ribbentrop and told him our wishes were to have Germany and Italy issue formal declarations of war on America at once. Ribbentrop replied that Hitler was in the midst of a conference at General Headquarters discussing how the formalities of declaring war could be carried out so as to make a good impression on the German people, and that he would transmit your wish to him at once and do whatever he was able to have it carried out promptly. At that time, Ribbentrop told me that on the morning of the 8th, that is before the declaration of war, Hitler issued orders to the entire German Navy to attack American ships whenever and wherever they might meet them. Goes without saying that this is only for your secret information." Then, as a matter of fact, as the tribunal are aware, on the 11th December 1941, this defendant Ribbentrop, in the name of the German government, announced a state of war between Germany and the United States. The next stage concerns his attempts to get Japan to attack the Soviet Union. In Ribbentrop's conversations with Oshima, the Japanese ambassador, in July 1942 and in March and April 1943, he continued to urge Japanese participation and aggression against the Soviet Union. This is shown in document 2911 PS, which has been put in as United States Exhibit 157 and already read. Document 2954 PS, which I now put in as GB 150. That is a new document, and if I might just indicate the effect of it by a very short quotation. It's a discussion between Defendant Ribbentrop and Ambassador Oshima. It begins, Ambassador Oshima declared that he had received a telegram from Tokyo, and he is to report by order of his government to the Reich Minister for Foreign Affairs the following. The suggestion of the German government to attack Russia was the object of a common conference with the Japanese government and the imperial headquarters, during which the question was discussed in detail and investigated exactly. The result is the following. The Japanese government absolutely recognizes the danger which threatens from Russia and completely understands the desire of its German ally that Japan on her part will also enter the war against Russia. However, it is not possible for the Japanese government, considering the present war situation, to enter into the war. It is rather of the conviction that it would be in the common interest not to start the war against Russia now. On the other hand, the Japanese government would never disregard the Russian question. And then in the middle of the next paragraph, this defendant returned to the attack. The third sentence begins in the fourth line. He says, however, it would be more correct that all powers allied in the three-power pact would combine their forces to defeat England and America, but also Russia together. It is not good when one part must fight alone. Then the pressure on Japan to attack Russia is shown again in the next document, 2929 PS, which was put in as United States Exhibit 159. And if I might just to close that this part of the case, if I might read that, for it's very short. The Reich Minister for Foreign Affairs then stressed again that without any doubt this year presented the most favorable opportunity for Japan. If she felt strong enough and had sufficient anti-tank weapons at her disposal to attack Russia, which certainly would never again be as weak as she is at the moment being 18th of April 1943. If the tribunal please, that concludes my evidence on the second allegation dealing with aggressive war. And I submit that that allegation in the indictment is more than amply proved. The third allegation is that the defendant Ribbentrop authorized, directed, and participated in war crimes and crimes against humanity. Because I am considering this from the point of view of planning these crimes only. The execution of the crimes will be dealt with by my French and Soviet colleagues. But it is relevant to show how this defendant participated in the planning of such crimes, and I deal first with the killing of Allied aviators, secondly with the destruction of peoples in Europe, and thirdly with the persecution of the Jews. First, the killing of Allied aviators. With the increasing air raids on German cities in 1944 by Allied air forces, the German government proposed to undertake a plan to deter Anglo-American flyers from further raids on the Reich cities. And in a report of a meeting at which a definite policy was to be established, there is stated what was the point of view that this defendant Ribbentrop had been urging. That is in document 735 PS, which I now put in as Exhibit GB 151. That is a discussion of a meeting at the Führer's headquarters on the 6th of June 1944. And if I might read the first paragraph. Obergruppenführer Kaltenbrunner informed the Deputy Chief, WEST, in Klesheim on the afternoon of the 6th of June that a conference on this question had been held shortly before between the Reich Marshal, Defendant Goering, the Reich Foreign Minister, the Defendant von Ribbentrop, and the Reichsführer SS Himmler. Contrary to the original suggestion made by the Reich Foreign Minister, who wished to include every type of terror attack on the German civilian population, that is, also bombing attacks on cities, it was agreed in the above conference that merely those attacks carried out with aircraft armament aimed directly at the civilian population and their property should be taken as the standard for the evidence of a criminal action in this sense. Lynch law would have to be the rule. On the contrary, there has been no question of court-martial sentence or handing over to the police. That is, that this defendant was pressing that even where there was an attack on a German city, the airmen should be handed over to be lynched by the crowd. The others were saying that that should be restricted to cases where there were attacks by machine guns or the like on the civilian population. Then the next, I don't think you need trouble with paragraph A of the statement of the Deputy Chief of the WEST, but if you look at B, because the importance of A goes because Kaltenbrunner says that there were no such cases as were mentioned. If you look at B, Deputy Chief of the WEST mentioned that apart from Lynch law, a procedure must be worked out for segregating these enemy aviators who are suspected of criminal action of this kind until they are received into the reception camp for aviators at Oberursel. If the suspicion was confirmed, they would be handed over to the SD for special treatment. That, as I understand that, it is if they weren't lynched under the first scheme by the crowd, then they were to be kept from prisoners of war, where they would, of course, be subject to the protecting powers intervention, and if the suspicion was confirmed, they'd be handed over to the SD to be killed. Then, in paragraph 3, we have what was decided to justify lynch law. Paragraph 3 says, at a conference with Colonel von Brauchitsch, representing CNC Air Force, on the 6th of June, it was settled that the following actions were to be regarded as terror actions justifying lynch law: low-level attacks with aircraft armament on the civilian population, single persons as well as crowds, shooting on our men in the air who were bailed out, attacks with aircraft armament on passenger trains in the public service, attacks with aircraft armament on military hospitals and hospital trains, which are clearly marked with the Red Cross. These were to be the subject of lynching, and not, as this defendant had suggested, the case where there was the bombing of a city. Then on the next page, the last page of this document, we have a somewhat curious comment from the defendant Keitel. Remarks by the chief of the OKW on the agenda dated 6th of June 1944. And the number is that of the document of which the tribunal has just been looking. Most secret, staff officers only. If one allows the people to carry out lynch law, it is difficult to enforce rules. Minister Director Brent got out and shot the enemy aviator on the road. I am against legal procedure. It doesn't work out. Signed, Keitel. Then the defendant Yodel's comments then appeared. This conference is insufficient. The following points must be decided quite definitely in conjunction with the Foreign Office. 1. What do we consider as murder? Is RR in agreement with point 3b? How should the procedure be carried out? A. By the people. B. By the authorities. 3. How can we guarantee that the procedure be not also carried out against other enemy aviators? 4. Should some legal procedure be arranged or not? Signed, Yodel. It is important, I respectfully submit, to note that this defendant and the Foreign Office were fully in on these breaches of the laws and usages of war, and indeed the clarity with which the Foreign Office perceived that there were breaches of the laws and usages of war is shown by the next document, which is 728 PS, which I now put in as GB 152. And that is a document from the Foreign Office, approved of by the defendant Ribbentrop and transmitted by one of his officials called Ritter. And the fact that it is approved by this defendant is specifically stated in the next document, 740 PS, which I put in as GB 153. I don't think this document has been read before, and therefore again I'd like just to read one or two passages in it. It begins, in spite of their obvious objections founded on international law and foreign politics, the Foreign Office is basically in agreement with the proposed measures. In the examination of the individual cases, a distinction must be made between the cases of lynching and the cases of special treatment by the Security Service, SD. 1. In the case of lynching, the precise establishment of the circumstances deserving punishment, according to points 1 and 4 of the communication of 15th June, is not very essential. First, the German authorities are not directly responsible, since death had occurred before a German official became concerned with the case. Furthermore, the accompanying circumstances will be such that it will not be difficult to depict the case in an appropriate manner upon publication. Hence, in cases of lynching, it will be of primary importance correctly to handle the individual case upon publication. The suggested procedure for special treatment by the SD, including subsequent publication, would be tenable only if Germany, on this occasion simultaneously, would openly repudiate the commitment of international law presently in force and shall still recognized by Germany. When an enemy aviator is seized by the army or by the police and is delivered to the air forces, prisoner of war reception camp over Sersel, he has received by this very fact the legal status of a prisoner of war. The Prisoner of War Treaty of 27 July 1929 establishes definite rules on the prosecution and sentencing of the prisoner of war and the execution of the death penalty, as for example in Article 66. Death sentences may be carried out only 3 months after the protecting power has been notified of the sentence. In Article 63, a prisoner of war will be tried only by the same courts and under the same procedure as members of the German armed forces. These rules are so specific that it would be futile to try to cover up any... Sorry, Lordship, please. I'll go back just a sentence. A prisoner of war will be tried only by the same courts and under the same procedure as members of the German armed forces. These rules are so specific that it would be futile to try to cover up any violation of them by clever wording of the publication of an individual incident. On the other hand, the Foreign Office cannot recommend on this occasion a formal repudiation of the Prisoners of War Treaty. An emergency solution would be to prevent suspected flyers from ever attaining a legal prisoner of war status. That is, that immediately upon seizure they be told that they are not considered prisoners of war but criminals, that they would not be turned over to the agencies having jurisdiction over prisoners of war, hence not go to a prisoner of war camp, but that they would be delivered to the authorities in charge of the prosecution of criminal acts, and that they would be tried in a summary proceeding. If the evidence at the trial should reveal that the special procedure is not applicable to a particular case, the flyers concerned may subsequently be given the status of prisoner of war by transfer to the Air Force reception camp. Naturally, not even this expedient will prevent the possibility that Germany will be accused of the violation of existing treaties, and maybe not even the adoption of reprisals upon German prisoners of war. At any rate, this solution would enable us clearly to define our attitude, thus relieving us of the necessity of openly having to renounce the present agreements, or of the need of having to use excuses which no one would believe upon the publication of each individual case. I don't want to take this in detail, but I ask the tribunal to look at the first sentence of section 3. It follows from the above that the main weight of the action will have to be placed on lynchings should the campaign be carried out to such an extent that the purpose, to wit, the deterrence of enemy aviators, is actually achieved, which goal is favored by the Foreign Office, then the strafing attacks by enemy flyers upon the civilian populations must be stressed in a completely different propagandist manner than heretofore. Well, I don't think I need trouble the tribunal, but that shows quite clearly the defendant's point of view, because if the tribunal would look at the next document, it is stated that the minister, for the beginning of the second paragraph, Ritter has advised us by telephone on 29th June that the Minister for Foreign Affairs has approved this draft. That is the position as to the treatment of aviators, where there is in my submission a completely cold-blooded and deliberate adoption of a procedure evading international law. The second section is the destruction of the peoples in Europe. With regard to Poland, again, I want scrupulously to avoid going into details, but I remind the tribunal of the evidence of the witness, Lahusen, which appears on the transcript, pages 618, 619, the 30th November of last year, and on pages 713 to 716, when he was cross-examined on the 1st of December. Secondly, Bohemia and Moravia. On the 16th of March 1939, there was promulgated the decree of the Führer and Reich Chancellor, signed by Ribbentrop, concerning the protectorate of Bohemia and Moravia. That is already in as Exhibit GB8, it's document TC 51. But the position, the effect of that was to place the Reich Protector in a remarkable position of supremacy under the Führer. The only part which I'd like the tribunal to have in mind is Article 5, sub-article 2, it shall be the duty of the Reich Protector as representative of the Führer and Reich Chancellor, and
Which
as the
document are you on
agent
now?
of the government of the Reich.
Which document are you on?
Article 5.2.
Of which document?
Well, I was reading it actually from the trial brief where it's copied out, but it's Article 51, in document 51, GB 8, page 2, at the bottom of the page. Begins the Reich Protector, as representative of the leader and Chancellor of the Reich, and as Commissioner of the Reich government is charged with the duty of seeing to the observance of the political principles laid down by the leader and Chancellor of the Reich. 3. The members of the government of the Protectorate shall be confirmed by the Reich Protector. The confirmation may be withdrawn. 4. The Reich Protector is entitled to inform himself of all measures taken by the government of the Protectorate and to give advice. He can object to measures calculated to harm the Reich, and in cases of danger, issue ordinances required for the common interest. And then the promulgation of laws, etc., and the execution of administrative measures and legal judgments shall be annulled if the Reich Protector enters an objection. The effect, as a result of this law, the 2 Reich Protectors of Bohemia and Moravia and their various deputies were appointed, and then there were committed the various crimes which will be detailed by my Soviet colleague. Similarly, with regard to the Netherlands, on the 18th of May 1940, a decree of the Führer was signed by Ribbentrop concerning the exercise of governmental authority in the Netherlands. And that, which is document 639, which I put in as GB 154, in Section 1 says the occupied Netherlands territories shall be administered by the Reich Commissioner for the occupied Netherlands territories. The Reich Commissioner is guardian of the interests of the Reich and vested with supreme civil authority. Dr. Arthur Seyss-Inquart is hereby appointed Reich Commissioner for the occupied Netherlands territories. On the basis of this decree, the Reich Commissioner, Defendant Seyss-Inquart, promulgated such orders as that of the 4th of July 1940, dealing with the confiscation of property of those who had or might have furthered, of those who had or might have furthered activities hostile to the German Reich, and tentative arrangements were made for the resettlement of the Dutch population. But all this will also be dealt with fully by my French colleague. I simply, for the moment, put in as a matter of reference the general order of the defendant Seyss-Inquart, which is GB 155, the document being 2921 PS. I don't intend to read it. I've summarized the effect of it, and it will be dealt with more fully by my French colleagues. I want the tribunal to appreciate that with regard to these 2 matters, Bohemia and the Netherlands, the charge against this defendant is laying the basis and procuring the governmental structure under which the war crimes and crimes against humanity were directed. Finally, I come to the persecution of the Jews, and the first, I should also put in, if I may just formally put in as Exhibit GB 156, the discussion on the question of the Dutch population, which is contained in document 1520 PS. Again, I've explained it generally, and I don't want to occupy time by reading it in full now. But then coming to the Jews, in December 1938, the defendant Ribbentrop, in a conversation with Monsieur Bonnet, who was then Foreign Minister of France, expressed his opinion of the Jews, and that was reported by the United States Ambassador, Mr. Kennedy, to the State Department, and the report of Mr. Kennedy is document L205, which I now put in as Exhibit GB 157. If I might read to the tribunal the second paragraph, which concerns this point. During the day, we had a telephone call from Béranger's office in Paris. We were told that in the matter of refugees had been raised by Bonnet in his conversation with von Ribbentrop. The result was very bad. Ribbentrop, when pressed, had said to Bonnet that the Jews in Germany, without exception, were pickpockets, murderers, and thieves. The property they possessed had been acquired illegally. The German government had therefore decided to assimilate them with the criminal elements of the population. The property which they had acquired illegally would be taken from them. They would be forced to live in districts frequented by the criminal classes. They would be under police observation like other criminals. They would be forced to report to the police as other criminals were obliged to do. The German government could not help it if some of these criminals escaped to other countries which seemed so anxious to have them. It was not, however, willing for them to take the property which had resulted from their illegal operations with them. There was, in fact, nothing that it could or would do. That succinct statement of this defendant's views on Jews is elaborated in a long document which he had sent out by the Foreign Office, which is numbered 3358 PS, which I put in as Exhibit 158. I don't want to read the whole of that document because it is excessively dreary, if also an excessively clear indication of the defendant's views on the treatment of Jews. But if the tribunal would look at first of all at page 3, after it's headed, "The Jewish Question as a Factor in German Foreign Policy," in the year 1938. Now, after the 4 divisions, the document goes on to say, "It is certainly no coincidence that the fateful year 1938 has brought nearer the solution of the Jewish question simultaneously with the realization of the idea of Greater Germany. Since the Jewish policy was both the basis and consequence of the events of the year 1938. That is elaborated, and if the tribunal will turn over to page 4, the beginning of the second paragraph, you'll see the first sentence: "The final goal of German Jewish policy is the emigration of all the Jews living in Reich territory." Then that is developed at great length for a large number of pages, and the conclusion, which is, if the tribunal would turn to the foot of page 7, having examined it, as I say, at inordinate length, it goes on this way: "These examples from reports from authorities abroad can, if desired, be amplified, they confirm the correctness of the expectation that criticism of the measures for excluding Jews from German Lebensraum, which were misunderstood in many countries for lack of evidence, would only be temporary and would swing in the other direction the moment the population saw with its own eyes and thus learned what the Jewish danger was to them. The poorer and therefore the more burdensome the immigrant Jew is to the country absorbing him, the stronger this country will react, and the more desirable is this effect in the interest of German propaganda. The object of this German action is to be the future international solution of the Jewish question, dictated not by false compassion for the united religious Jewish minority, but by the full consciousness of all peoples, of the danger which it represents to the racial composition of the nations. The tribunal will appreciate that this document was circulated by the defendant's ministry, widely circulated to all senior Reich authorities, numerous people, before the war on the 25th of January 1939. So just after the statement to Monsieur Bonnet. And apparently the anti-Semitism of the defendant went from, I was going to say strength to strength, if that is the correct term, or at any rate from exaggeration to exaggeration, because in June 1944, the defendant Rosenberg made arrangements for an international anti-Jewish Congress to be held in Krakow on the 11th of July 1944. The honorary members were to be the defendant von Ribbentrop, Himmler, Goebbels, and Frank, I think the defendant Frank. The Foreign Office was to take over the mission of inviting prominent foreigners from Italy, France, Hungary, Holland, Arabia, Iraq, Norway, etc., in order to give an international aspect to the Congress. However, the military events of June 1944 prompted Hitler to call off the Congress, which had lost its significance by virtue of the landings in Normandy. But that is contained in document 1752 PS GB 159, and at the foot of page 1, the tribunal will see the following have been entered as honorary members: Reich Foreign Minister Joachim von Ribbentrop. So that there is no doubt that this defendant was behind the program against the Jews, which resulted in the placing them in concentration camps with anyone else who opposed the Nazi way of life, and it is submitted that he must have, as a minister in special touch with the head of the government, have known what was going on in the country and in these camps. One who preached this doctrine and was in a position of authority cannot, I submit to anyone who has had any ministerial experience, suggest that he was ignorant of how the policy was carried out. That is the evidence on the third allegation, and it is submitted that by the evidence which I have recapitulated to the tribunal, the three allegations are proved. With regard to the second, Hitler's own words were In the historic year of 1938, the Foreign Minister von Ribbentrop was of great help to me in view of his accurate and audacious judgment and the exceptionally clever treatment of all problems of foreign policy. During the course of the wars, this defendant was in close liaison with the other Nazi conspirators. He advised them and made available to them from his embassies and legations abroad information that was required, and at times participated, as I have shown, in the planning of war crimes and crimes against humanity. It is submitted that all the allegations which I read from the Appendix A to the indictment are completely proved against this defendant. I only want, if the tribunal will allow me, to add one fact on behalf of the British delegation. In the preparation of these briefs, we have received great assistance from certain of our American colleagues, and I should like to say once, but nonetheless heartily, on behalf of us all, to thank Dr. Kempner's staff, Captains Auchincloss, Cleggett and Stoll, Lieutenants Felton and Heller, and Mr. Lachman for the great help they've been to us.
We'll adjourn now for 10 minutes.